Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been discussion in the general public regarding defense expert Cy Ray's recent book and comments in an interview that he gave to the Custody Queens podcast, where he stated words to the effect he felt the evidence showed that Mr. Kohberger was guilty of the crimes that occurred at 1122 King Road. In addition, Mr. Ray suggested the world may not have heard the last from Mr. Kohberger, implying that there may be some sort of an appellate proceeding coming down the line. But he used three magic words at least three times in his interview: miscarriage of justice. That is the legal standard that was announced recently in the landmark case of Hunter versus United States. The ruling that came down from SCOTUS, June 18, 2026, states Petitioner Munson Hunter III was charged with 10 counts of bank and wire fraud for a years-long scheme costing various financial institutions about $500,000. He entered into a written plea agreement with the government under which he pleaded guilty to one count of aiding and abetting wire fraud in exchange for dismissal of the remaining 9 charges and a promise not to prosecute him for the described conduct in future. The agreement included an appeal waiver under which Hunter waived the right to appeal his conviction and sentence, except he did not waive the right to appeal a claim of ineffective assistance of counsel. Ladies and gentlemen, if I could interject, during the Kohberger case, which ended in July of 2025 with Mr. Kohberger's agreeing to change his plea to guilty to the 5 very serious felonies he was about to stand trial on, the term ineffective assistance of counsel, the defense counsel would not be able to effectively defend Mr. Kohberger if something didn't happen. For example, if discovery wasn't turned over, and that was a continuing theme throughout the case. This phrase that Mr. Kohberger is entitled to effective assistance of counsel, and there was a question that she could not effectively assist him because of actions attributable to the state. Mr. Kohberger did not, in his plea agreement, have an agreement where he would not waive the right to raise a claim of ineffective assistance of counsel in an appeal. Hunter did, Kohberger didn't. Going on to page number 2 of the Hunter decision, here's the ruling. An agreement not to appeal a sentence is unenforceable when it would result in a miscarriage of justice, meaning when it would leave in place the kind of egregious error that would bring the judicial system into disrepute. In looking at this new Hunter standard, the law of the land effective on June 18th, 2026. If a party can show a miscarriage of justice under Hunter, there's a possibility that they would be able to have an appellate court take a look at what happened, for example, in sentencing or in the imposition of the conviction. Now, there is no facts on the record other than what Mr. Ray has alluded to, that Mr. Kohberger has any intention to appeal anything, has appealed, will appeal, and we've had a look at the docket in Ada County. That's where a petition for post-conviction relief would need to be filed. Why is it? Because the statute that governs post-conviction relief in Idaho says so. Idaho Code Section 194901. That's the part of the Idaho statutes where petitions for post-conviction relief is located. There is no indication as of today, July 17th, 2026, that Mr. Kohberger has filed a petition for post-conviction relief. We're going to continue to look at the docket in Ada County. That's where the sentence and the conviction was imposed. That's where the petition for post-conviction relief would need to be filed. So please stay tuned. If you have any thoughts, any comments regarding this matter, let us know. Your opinions are important. Until next time, this is Kathy. Thank you for joining us here today.